Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Linda Bennett. Here. Corey Bird. Corey Michael Bird. He's in custody, or it just says federal, court. He's in federal custody. Well, that makes sense what he's not here. I'll recall Mr. Bird's case. Ronnie Callahan. Here. Cortez Cozy. Here. Is it Cozy or Cossey? Cozy. Trevor Glover. Here. Yazdeed Nat. Here. Shiloh Scott. Present. Thank you, Mr. Garrison. Daniel Admire. Ashley Holzhauser. Here. Dante Major. Mark Thomas. Mark Aaron Thomas.
He's running a little bit late, Judge. I expect him.
Thank you, Mr. Schmidt. John Ross. Jace Quaid. For the record, Charles Kenneth Bell, cause numbers CR 24-298, CR 25-1. Mr. Bell is represented by Mr. Wells. Mr. Wells has filed a waiver of arraignment that's been accepted and approved. Pretrial is set March 25th in each case. Roger Bridges. Here. Is there anyone whose name is not being called this morning? Do we have any counsel that's ready? Mr. Harrison, I saw you move first. Mr. Thorson was sleeping on it, and then y'all looked at each other. But he's younger and quicker, so
and we approach.
Yes. Wait, come on up.
The other way.
Just come straight across. There you go. Sir. This is State of Texas versus Jace Dale Quaid, cause number CR 24-222 and 223. Show that we're set for pretrial today. Mr. Thorson, any contested pretrial motions?
No, Your Honor, we don't have any contested pretrial issues in this case.
Very well. All right. Then the court will set this case for docket call. We'll set this for April 15th at 9 a.m. And once Mr. Quaid signs and gets his notice, he's free to go.
Thank you, Judge. May I be excused, Your Honor?
Yes, free to go. Shiloh Scott, CR 24225. Ms. Scott is set for pretrial today. Mr. Harrison?
She is, Judge. We have discovery. We filed motions. We don't have anything that requires a ruling today. I've been speaking with Ms. Curry about the case. We're continuing to keep the dialogue open, but we just need, I guess, our next setting for pretrial is all we have today.
Okay. You requesting any specific amount of time? 30 days sufficient?
Probably 30 days, Judge.
Mr. Harrison, you available? March is a little tough. I've got a 2-week civil trial and then you've got spring break in there. I've got one setting on March 25th for all of my criminal cases. It's the last Tuesday in March.
Yes, sir.
Is that fine? Okay. All right, court sets Ms. Scott then for docket call March 25th at 9 a.m. And once she signs her notice of appearance, she's free to go.
And that would be excused, Judge.
Free to go.
Thank you. Good seeing you.
Good to see you. You're gonna want that to be on Harrison. Mr. Harrison, you need to have that reset date on there.
Pardon, Your Honor.
Good morning, come on up.
John Ross.
John Robert Ross, cause number CR 24224. All right, Mr. Ross is set for docket call today. Go ahead.
We have a plea worked out, Your Honor, so we're asking to reset for a plea setting.
Okay, plea before the court.
And Your Honor, I believe there is a waiver of jury just to, because this one's been on fifth setting.
Do you have the waiver of jury trial form?
Yes, Your Honor.
Go ahead and bring that forward. Mr. Ross, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can lower your hand. Mr. Ross, I'm going to ask you some questions only about this waiver of jury trial, okay? Mr. Ross, you're currently represented by your attorney, is that correct? Can you hear me okay?
I'm just a little hard here.
Well, come on up. Come up with them. Right here in this little blue square right here. That might be better for you. All right, so Mr. Ross, you're represented by your attorney, Mr. Stevens, is that correct? Yes, sir. And you've executed a document today called Waiver of Jury Trial, is that correct? Yes, sir. And in this waiver of jury trial, what this means is that you're indicating to the court that you understand that you have the right to have your case tried before a jury of your peers to determine whether you're guilty or not guilty. And in that process, to contest the state's evidence and witnesses against you. You understand that? And in that process, you have your attorney to help aid you and give you legal advice and representation during that process. You understand that? Yes, sir. And you understand that you and only you can waive that right to a jury trial. Mr. Stevens can't do it. I can't do it. Prosecution can't do it. Only you can do that. You understand that? Yes, sir. Are you making the decision today for yourself, an independent decision to where you're not feeling forced, pressured, or coerced to make this decision? Are you doing this because this is what you want to do?
I'm just trying to get along.
You're trying to do what?
Get along.
Get along? Well, what does that mean?
Not to fraud the system. I just want to work with the system. It was a bad incident.
Okay, well, I don't want you to say anything in case this doesn't turn out the way that you want it to. I don't want you to say anything that you could be used against you. But what I need to know today is that you understand how this process works, that the state of Texas has filed an indictment, which is a criminal accusation against you. And they intend to take that case to trial. And at trial, they would be forced to prove that you committed the offense beyond a reasonable doubt. They'd have to convince the jury of doing that. If you had a jury trial, you get to decide whether you have a jury trial or not. And if you decide, I do not want a jury trial and I want to enter a plea agreement to try to resolve the case, that's fine. You can do so. But I need to make sure that you understand that once you give up your right to a jury trial, you may not get that back. Meaning you can't enter into a plea agreement and then maybe mess up on probation and say, oh, judge, you know what? I'm innocent of that charge. I want to go back and have a jury trial and prove my case that I'm innocent. You understand that?
Yes.
All right. So has Mr. Stevens or the prosecution or anyone else made you feel like you had to waive your right to a jury trial today and that you have to enter into a plea agreement? Or are you making this decision because you've evaluated all of the facts, you've received the advice of your attorney, and you've made the independent decision that this is what you want to do for your case?
I figured this is the best route.
Okay. And so has anyone threatened you, forced you, or pressured you to waive your right to a jury trial?
Not to do this.
I need you to answer my specific
No,
question.
no.
Okay, you can't.
I
can't-
have it. I have, no.
Okay, and I understand that you may be nervous and might
Oh.
not be used to the situation, but I'm very specific. I need to know, has anyone threatened you to waive your jury trial? Has anyone forced you to waive your jury trial? Has anyone pressured you and made you feel like you had to make this decision of waiving your jury trial? Okay, thank you. All right, Mr. Stevens, you've counseled your client, Mr. Ross, on what it means to waive his right to jury trial.
Yes, sir.
And do you believe that he is entering into this intentionally, knowingly, and voluntarily?
Yes, sir.
All right. Then the court finds that Mr. Ross, having been admonished as to his right to a jury trial, has waived the same intelligently, knowingly, and voluntarily with the assistance and advice of counsel. Also, the court finds that the attorney for the state has waived its right to a jury trial in this matter. The court hereby approves the waiver of jury trial and will set Mr. Ross for plea agreement before the court. And so, Mr. Stevens, how much time do you need? How much time do you want me to reset this?
Would March 11th be okay?
Well, no. Because that's spring break. I don't have any setting.
Oh, okay.
My next available, you can come back next week on the 18th, if you just want a week.
That's probably too soon.
Other than
with
that-
My calendar.
Other than that, it would be March 25th. So February 18th or March 25th,
Let me double check.
or maybe even possibly February 20th.
No, definitely not 18th.
What about the 20th?
20th isn't good either.
All right, so March 25th it is.
Thanks, Sean.
All right, and do you have a notice of appearance form? If
I
you'll
do, Your Honor.
fill that out, have Mr. Ross sign that. Once you get your copy, Mr. Ross, you're free to go. We'll see you back on March 25th.
Give this to you. Thanks, Sean.
Oh, hang on, here we go. Yes, let me make sure that looks good. Date, let's see. Here, let me see that yellow copy. I'm just going to correct this because it says January 11th. Today's February 11th.
I'm one behind.
All right, 3:25, 9 a.m. All right, Mr. Ross. See you back on that date.
Thanks, Your Honor.
Date, Mr. Stevens.
Your Honor.
Good morning, sir.
How are you?
Doing fine yourself?
Good. On Jazz Deep Nat.
Yes, sir. All right, this is cause number CR 22-72, State versus Yazdi Singh Nat, and we're set for docket call today.
That's correct, Your Honor.
Any announcements?
The only announcement we have is that he's still working on the Hunt County case. It's clear set and on the 24th of this month. So we'll have an outcome by then.
And Your Honor, we've been kind of allowing the Hunt County case to play out because that was the primary violation on the PTI. So we were kind of letting that play out to see where we land on this.
When did you say his hearing date was in Hunt County?
It'd be on the 24th of this month.
24th of this month. Okay. It's like March 25th.
That'll work, Your Honor.
All right, court sets Mr. Nat for docket call March 25th, 9 a.m. And so that will be the final docket call on this case.
Yes,
So either you'll have a resolution or you'll tell me that day that you want to have a bench trial or a jury trial.
Yes, Your Honor.
Okay.
Thank you.
And once he signs and gets his yellow copy, he's free to go.
Thank you.
Mr. Hartwell, is this a motion to revoke or a motion to adjudicate?
this is a unsuccessful PTI.
Okay, you said underlying offense, or you said underlying, so I didn't know if it was,
Oh, okay.
if it was a count, so that's okay.
Yes, sir.
I just want to make sure we didn't need to put it on an evidentiary day,
Yes, sir.
but we're good. Ronnie Callahan. This is cause number CR 25-5, State of Texas versus Ronnie Liddell Callahan. Mr. Callahan, you have been indicted with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years in prison, up to a maximum 10 years in prison, and a possible fine not to exceed $10,000. I see that you have requested a court-appointed attorney. The court's reviewed your application, and due to your financial circumstances, the court does not find you to be at that poverty level that's required for a court to appoint you an attorney. So what I can do is I can reset your case and give you time to go out and make arrangements to hire an attorney. Do you want me to do that?
Yes, sir.
Okay. If I reset this case until March 25th, that's about 45 days. Feel like that's enough time that you'll be able to hire an attorney to represent yourself?
Yes.
Okay. And Mr. Callahan, do you speak English?
I'm biracial.
Okay, well, no, I'm not looking at I'm looking at
Yes.
your voice and your dialect.
Oh,
So it
okay.
was just a short yes. I wanted to make sure.
Yes.
Okay, all right. So Mr. Callahan, I'm going to reset you to March 25th. She's going to bring you this notice of setting. Sign that. You'll get a yellow copy.
Just
We'll see
before
you
my
back.
birthday.
What's that?
It's just before my birthday.
Okay, good.
Yes, they have to have a license. Texas.
Yes.
There's your notice.
Oh, that's fine.
Back on March 25th.
Same time, 9 o'clock.
Okay, thank you.
You're welcome.
That it?
Yes, sir. You're free to go.
Okay, thank you.
When did we reset John Ross? 325, right? Per plate, right? I didn't write that one down. We're gonna go ahead and go on record and cause number CR 24-201, 202, 203, 204. State of Texas versus Corey Michael Byrd. Mr. Byrd is in federal custody. Set for pretrial on March 17th. So that's per Miss Cindy Davis at the bail bond company. So we're gonna reset Mr. Byrd to April. We'll set up for status on April 8th. Let's see if we can get any updates from the federal case.
Yes, sir.
And Mr. Hartwell, if you can reach out to the federal prosecutor and get us more specific information,
Yes, sir.
that would be great.
From what I've heard, I haven't been able to confirm, but I believe one of his federal charges is a felon in possession, which could very well be one of ours. So if they end up kind of taking over, we'll let the court know and file whatever dismissals are required.
All right, the remainder of you are represented by Mr. Schmidt. So he's out working, I believe, with his clients. So I'm going to stand in recess for at least 20 minutes. So you're not required to sit in the courtroom. You can move about. So just check back. It's 9:30, say about 10 o'clock. Check back in here about 10 o'clock and make sure that you check in with Mr. Schmidt, let him know where you're at in case he needs to talk to you. Okay. Court's in recess. Man, who'd you like to call first?
Daniel Admire.
Mr. Admire? This is cause number CR 24-250 and 251. State of Texas versus Daniel Jack Admire for arraignment on the 250 pretrial 251.
Judge, on the 250, we waived formal reading. We had received that previously. It didn't get waived. Interplea not guilty to that offense. Asked that both of these matters be set, I guess, for doc call.
Well, we'd said we could set this other one for pretrial unless you.
Well, we can carry them both then for a pretrial. That way they're together. I think they're the same allegation transaction.
Court finds that Mr. Admire, having waived the formal requirements of arraignment, enters his plea of not guilty to cause number CR 24-250. The court will set this case for pretrial hearing concurrent with cause number 251. You want to set that on March 25th?
Yes, sir.
It'll be at 9 a.m.
Really good.
Good to go.
Ashley Holzhauser.
Ashley Holzhauser, CR 24-263, 264, 265, 266, and 267. Schmidt, I think we're set for pretrial on all these cases.
Judge, on CR 25, 17, 18, and we had intended to waive arraignment on those two. I think that we dropped the ball on the forms, but we'd waive formal reading on those. Interplea of not guilty, asked to carry these together for an additional pretrial setting. I've been discussing the case with Mr. Hartwell, and we're seeking some itemized documentation on potential restitution.
Okay, which cases? I don't show any cases set for arraignment today. Which ones do you think?
It should have been the last, I believe the last two in the cause sequence that.
266 and 267.
Right, I filed written waivers on the other ones and I think we missed those last two. Either way, they're all the same transaction, so we can carry them together.
Okay. All right, if Ms. Holzhauser's not been arraigned on 266 and 267, court finds that she has waived the formal requirements of arraignment, enters her plea of not guilty into the record, and sets the matter for pretrial. Is March 25th sufficient time?
Yes, sir.
I think so, Your Honor.
My court sets all cases. Ms. Holzhauser, March 25th at 9 a.m.
Trevor Glover.
All right, this is cause number CR 25-8, State versus Trevor Cole Glover for arraignment.
Yes, sir. I received a copy of the indictment. We've gone over that. His name's correct. We'll wait formal reading, enter a plea of not guilty, ask for a pretrial setting.
All right, the court finding that Mr. Glover has formally waived the requirements of arraignment, enters his plea of not guilty into the record, sets this matter for pretrial hearing March 25th at 9 a.m. Once he signs, he's free to go.
Linda Bennett.
Linda Diane Bennett, CR 25-4. And it's set today for arraignment on criminal mischief.
That's correct, Judge. We received a copy of the indictment. We Understand the charges, name spelled correctly, enter a plea not guilty, ask for pretrial.
Court finding that Ms. Bennett has waived the formal requirements of arraignment, enters her plea of not guilty into the record and sets this matter for pretrial hearing on March 25th at 9 a.m.
Yeah.
See you later. Cortez Cozy.
Mr. Cozy, if you'll come forward, sir. This is cause number CR 25-6, State of Texas versus Cortez DeMonte Cozy for arraignment. Good, Mr. Schmidt.
Judge, I've gone over the indictment with Mr. Cozy. His name's correct, understands the charges, waived formal reading, enter a plea not guilty. Ask for pretrial.
Court finding that Mr. Cozy, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. The court sets this matter for pretrial on March 25th at 9 a.m. Once he gets his notice, it's reading.
Thank you. See you later. Roger Bridges.
Mr. Bridges. Cause number CR 24-299, State of Texas versus Roger Neil Bridges. Mr. Schmidt, I just want to make a record real quick. Mr. Bridges was originally appointed counsel the county, and Mr. Jim Wheeler was appointed because the case, I believe, started off as a misdemeanor. And Mr. Wheeler was court appointed counsel in the county court of law for Judge Winters case, having been indicted as a felony and filed into this court. The court did inquire with Mr. Wheeler, who had already met with Mr. Bridges while he was incarcerated, to determine whether or not Mr. Wheeler could continue in representation. And Mr. Wheeler had indicated to court staff, Abraham, that he was unable to serve in a dual appointment role in two district courts as he's bound in Smith County under their contract system. So he had acquiesced and understood that the court would be amending the appointment today, removing Mr. Wheeler as Mr. Bridges' attorney because of that reason, and appointing you, Mr. Schmidt. So.
Yes, sir, I understand this, I understand that. Okay. We're set for an arraignment, I believe we're ready to proceed.
All right, go ahead.
And Judge, I have briefly reviewed the indictment with Mr. Bridges as well as the charges. His name spelled correctly. We'll enter a plea of not guilty today and ask for a pretrial sentence.
All right, the court finding that Mr. Bridges has remained indigent has appointed the Honorable Richard Schmidt as counsel for Mr. Bridges. Also, having waived the formal requirements of arraignment, the court enters Mr. Bridges' plea of not guilty into the record and sets this matter for pretrial hearing on March 25th at 9 a.m. Mr. West, have you already met with Mr. West? Okay.
Did he need to meet with Mr. West, Judge?
No, he's good to go.
All right, you're good. Mark Thomas, did Mark Thomas show up, dude? Did we have Mark Thomas come in? I haven't seen him.
Not that I'm aware of. Not for this. Mr. Major?
As well, so no worries.
All right, this is cause number CR 24-214. The state of Texas versus Dante Marquez Major. Mr. Major, I see that you want to enter a plea before the court today to resolve your case. I'm gonna have you raise your right hand and place you under oath. Mr. Major, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. I think you can lower your hand. Mr. Major, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you? Do you understand everything that you have read and signed today as part of your plea agreement? Do you swear that your signature as it appears on the documents is true and correct, and that you only signed because you understood what you were signing? Yes, sir. Mr. Schmidt, do you believe that Mr. Major is competent to enter into this agreement? And if so, have you explained to him his rights, also including the advantages and disadvantages of the deferred adjudication period?
Yes, sir. The answer is yes to all three questions.
Mr. Major, you were indicted with third-degree felony offense of possession of a controlled substance in penalty group 2, greater than 1 grams, less than 4 grams. A third-degree felony does carry a range of punishment. If you were to be convicted and sentenced, it would be not less than 2 years in prison or more than 10 years in prison, and a fine, if imposed, not more than $10,000. I see that there's a plea agreement in your case. It appears, Mr. Major, that upon your plea of guilty, the DA's office is recommending to the court to consider the evidence and find that there is enough evidence to convict you. However, they're asking the court to defer a finding of guilt and not convict you, but rather place you on community supervision for a period of 42 months. In addition, you would have a $1,500 fine, court cost of $290, restitution of $180, and the DA's office would be asking the court to dismiss an unfiled possession of marijuana less than 2-ounce case. Is that your understanding of the plea agreement, Mr. Major? Yes, sir. All right, understanding all of those things, how do you plead to possession of a controlled substance in penalty group 2 greater than 1 grams, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Mr. Major, has anyone threatened you, forced you, or pressured you to plead guilty here today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection, Judge.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. Court, having reviewed the evidence, finds that there is sufficient evidence to convict Mr. Major of this offense. The court will follow the plea agreement and recommendation of the DA's office. The court hereby defers the finding of guilt, places Mr. Major on deferred community supervision for a period of 42 months on the charge of possession of a controlled substance in penalty group 2, greater than or equal to 1 gram, less than 4 grams. The court fines Mr. Major $1,500, orders restitution in the amount of $180, court costs in the amount of $290, and also orders Mr. Major to reimburse Van Zandt County for its indigent attorney fees in the amount of $535. In addition, the court does dismiss under section 1245 an unfiled possession of marijuana less than 2 ounces, DA 2024-400. Mr. Major, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come up here and Deputy Martinez is going to take your fingerprint. After that, Officer Mature will tell you more.
This is the back page of that judgment that he's going to put your fingerprint on, but we're showing them together.
So we sent to you. So do we need to wait on Mr. Thomas?
Yeah, if I'm gonna, I talked to him yesterday, so I'm gonna see if I can track him real quick. I don't know if I'm like,
Oh, hang on, I understand. Is there another issue that's before the court that you need to address with the Honorable Estelle Grisham certified? We'll be off the record for this.
I don't know, I'd like it on the records.
Would you like it on the record? I'll
Yes,
tell you what,
sir.
it'll be on the social media YouTube record, but it will be off.
You won't have to stand, my dear. In the last 15 years or so, Judge, I don't know how long you've been with Benson County, but 18 years.
Feels like 32.
That's right. Estella Grisham and I have had an adversarial relationship, particularly as it pertains to the placement of her electronic devices, which are inconveniently located, and they're also camouflaged,
Off limits to
which is
the badges.
also camouflaged. I'm ignoring the court reporter because she's interrupting me. In an effort to fix the problem that I believe she created, Judge, I have presented her with some microphone covers that are visible, huh?
But it's not a microphone, this is an amplifier.
You can take this off and put the color on.
Try it.
Let's see, Mr. Why don't you, we'll give you the ceremonial process of removing the black.
Put some.
I don't care about that. I believe you when you say that you have trouble. And what I'm telling you is that I can't see it.
No. Where's your ear?
It's little.
Now, hit that thing.
I'm hitting it. I don't see.
It's
the
not
problem.
that.
All I see is
Hit
drama. I see drama
No.
is what I see.
Hear it.
Anyway,
That does look good though. I like
But
it.
listen
does
how,
look much
listen how loud it is.
I think you are sensitive here.
I think she's dramatic.
I think
But
it's time
here's
to
the
retire. You're right. It's time to retire.
But here's the trick.
15 years is a long time.
It is. Here's the trick. When
I'm
we
at
put
the
that
end of my
here,
life.
you put that here, everybody will look at it. It will draw my attention to it. And I'll remember.
That's fine.
I'll remember not to hit where you place
But see,
your
this is
star.
off limits anyway, so I don't know why you're
I don't
placing
know.
anything
I don't
up
know
here.
what you mean by off
There's a-
limits. I don't know what you mean by off limits.
Off limits to everybody.
I'm routinely called upon as an officer of the court to reach past this automatic, this
This is it, right here.
false threshold.
This little bitty spot right here. That's
Yeah.
all I
Yeah,
say.
and look,
Do
and
not
look,
touch.
and now boom, I can see it's there. Simple
Okay.
fix.
Thank you. This is a.
I do like, Mr. Smith and I, we did discuss this issue and, God, in his infinite wisdom, designed plants and animals, with these vibrant colors to let people know, warning, don't touch, don't eat, don't come near. So now I think Mr. Schmidt has just borrowed.
Attorneys that come in here.
Inspired by the doors.
That come in, he is the only one.
Well, statistically speaking, I'm more likely to anyways.
Plus my eardrums.
Well, the first time was an accident. The second time made me not. You were pretty ugly about it.
Do you have any updates on Mr. Thomas?
Give me 30 seconds on this. Track.
Court's gonna stand in recess.
I'll keep it.
All right, we're on record. Court has called State of Texas versus Mark Aaron Thomas, cause number CR 25-1718. Mr. Thomas is set for arraignment today. Mr. Thomas has not appeared at 9 a.m. as ordered. The court has called his name loudly, distinctly 3 times with no response. The court hereby issues a judgment nisi alias capias, but the court's going to take that under advisement at the request of Mr. Schmidt, counsel for Mr. Thomas. We'll take that under advisement until noon on Thursday of this week, that being February 13th, 2025. Court, having concluded its morning docket, will stand in recess until 1:30 for the afternoon docket.